The Georgetown Law Center auditorium hummed with tension as former Attorney General William Barr leaned forward, a satisfied smile crossing his face. He had just delivered what he clearly believed was a knockout question to Congresswoman Jasmine Crockett during their televised debate on executive privilege. "Congresswoman," Barr said, his voice carrying a hint of triumph, "you've criticized my invocation of executive privilege during congressional investigations. Yet in 2022, you publicly defended the Biden administration's refusal to provide certain documents to Congress citing the same privilege. Isn't this the very definition of partisan hypocrisy?" A murmur rippled through the audience of law students and faculty as cameras zoomed in on Crockett. Barr sat back, arms folded, clearly expecting his gotcha moment to leave her flustered. Without missing a beat, Crockett reached into her portfolio and extracted a single sheet of paper. "Mr. Barr," she replied, her voice steady and precise, "I have here the exact statement you're referencing. What I actually said was that executive privilege exists for legitimate national security concerns, but never to conceal potential wrongdoing." She placed the document on the display screen where everyone could see it. "My exact words were, executive privilege serves a legitimate function when properly invoked, but becomes dangerous when abused to shield misconduct from oversight. That's a legal principle, not a partisan position." As Barr's satisfied expression dissolved into visible discomfort, Crockett continued, "The difference isn't who invoked the privilege, but whether it was invoked to protect legitimate deliberative processes or to obstruct investigations into potential misconduct. Would you like to discuss the specific context of each case?" The audience erupted in applause as Barr shuffled his papers, clearly thrown off balance by her meticulous preparation and precise response. What followed was not just a debate point scored, but a masterclass in constitutional oversight that would transform the public's understanding of executive privilege and accountability in ways that transcended partisan politics. Before we dive into how this remarkable exchange unfolded and its lasting impact on legal discourse, don't forget to like this video and subscribe to our channel for more in-depth analysis of the pivotal moments reshaping America's understanding of constitutional principles. To understand why this exchange sent shockwaves through legal and political circles, we need to examine the backgrounds of these two formidable legal minds and the context that brought them into this high-stakes public debate. Jasmine Crockett had built her reputation as one of the most intellectually rigorous members of Congress since her election in 2022. Before entering politics, she had established herself as a respected civil rights attorney in Texas, where she developed a reputation for methodical case preparation and an encyclopedic knowledge of constitutional precedent. "What separates Crockett from many of her colleagues," explained Professor Lawrence Tribe of Harvard Law School, "is her ability to cut through political rhetoric and focus on consistent constitutional principles. She approaches oversight not as a partisan exercise, but as a constitutional responsibility." This approach had earned her respect across the political spectrum. Unlike representatives who used hearings primarily for sound bites, Crockett became known for substantive legal analysis that exposed contradictions and inconsistencies other lawmakers often missed. "She doesn't play gotcha politics," noted a former Republican staffer who had observed her in committee hearings. "She identifies genuine tensions between stated principles and actual practice. That makes her particularly effective when questioning legal officials, regardless of party." William Barr, by contrast, had served as Attorney General under two Republican administrations, most recently during the final years of the Trump presidency. Throughout his career, Barr had developed a robust theory of executive power that emphasized presidential authority and limited congressional oversight. During his tenure as Attorney General, Barr had invoked executive privilege numerous times to decline providing documents and testimony to congressional committees investigating various administration actions. These decisions had generated significant controversy, with critics arguing that they represented an overly broad interpretation of executive privilege designed to shield potential misconduct from legitimate oversight. Since leaving office, Barr had become a frequent commentator on legal affairs, often defending his decisions and articulating his vision of a strong executive branch largely insulated from congressional intrusion. His book, One Damn Thing After Another, presented his actions as consistent applications of long-standing constitutional principles rather than partisan efforts to protect the president. The Georgetown Law Center debate titled Executive Power and Democratic Accountability had been organized as part of a series on constitutional separation of powers. The event had drawn significant attention given the participants' high profiles and their representing different perspectives on a fundamental constitutional question. When is executive privilege a legitimate protection of presidential deliberation? And when does it become an obstacle to necessary oversight? The specific exchange that sparked the confrontation stemmed from a question about consistency in applying constitutional principles. Barr had been asked about his broad invocation of executive privilege during congressional investigations into the Trump administration, and he had defended his approach as consistent with long-standing Department of Justice interpretations dating back to the Reagan administration. In his response, Barr had pivoted to suggesting that Democratic critiques of his decisions were purely partisan rather than principled, specifically citing what he claimed was Crockett's inconsistent position on executive privilege claims by different administrations. What Barr couldn't have known was that Crockett had anticipated precisely this line of attack. Having reviewed Barr's previous statements and writings, she had prepared comprehensive documentation of her own positions on executive privilege across administrations, demonstrating a consistent focus on the purpose and context of privilege invocations rather than the party of the president asserting the privilege. As Crockett displayed her actual statement, which emphasized principle over party, the audience of law professors and students recognized they were witnessing something significant. A confrontation not just between political figures with different partisan affiliations, but between fundamentally different approaches to constitutional interpretation and governmental accountability. What is your view on executive privilege? Should it be applied differently depending on the specific circumstances, or should it be consistently broad or narrow regardless of context? Share your thoughts in the comments below. As Crockett's precise response hung in the air, Barr attempted to regain his footing. Congresswoman, regardless of your exact wording, you've been more willing to accept privilege claims from Democratic administrations than Republican ones. The principle should apply equally regardless of party. Rather than becoming defensive, Crockett nodded. I completely agree with your last statement, Mr. Barr. The principle should indeed apply equally. That's precisely my point. The principle isn't about which party invokes the privilege, but why and how they invoke it. She opened a folder containing what appeared to be carefully organized case references. Let's examine specific invocations of executive privilege and see if they align with the established legal standards. This methodical approach shifted the conversation from political talking points to substantive legal analysis, territory where Crockett's preparation gave her a distinct advantage. In 1974, the Supreme Court ruled in United States v. Nixon that executive privilege is not absolute and cannot be used to withhold evidence relevant to a criminal investigation, she noted. That established a foundational principle that privilege claims must yield to specific demonstrated needs for information in criminal matters. She turned to Barr directly. In your 2019 memo directing former White House counsel Don McGahn to defy a congressional subpoena, you cited executive privilege to prevent testimony about potential obstruction of justice, a criminal matter. How do you reconcile that with the Nixon precedent? This precise legal question, focusing on specific actions rather than general politics, caught Barr slightly off guard. The Nixon case involved a grand jury subpoena in a criminal case, not a congressional investigation, he replied. Different standards apply. An important distinction, Crockett acknowledged. So let's look at congressional oversight specifically. In Committee on the Judiciary v. McGahn, the D.C. Circuit held that senior presidential advisors are not absolutely immune from compelled congressional testimony. Yet your Justice Department maintained exactly that position. Was that consistent with established precedent? Rather than waiting for Barr's response, Crockett continued her methodical analysis, displaying a chart that contrasted executive privilege claims across multiple administrations with the stated legal justifications for each claim. "What's striking about this data," she explained, "is not the party of the administration making the claim, but the breadth of the assertion relative to established precedent. The Trump administration's claims were remarkable not because they came from Republicans, but because they asserted virtually unlimited privilege without the narrow tailoring that courts have required." She turned to a specific example. When the Obama administration invoked executive privilege regarding the Fast and Furious operation, I publicly stated that they should provide all non-deliberative factual information to Congress while protecting only actual presidential communications. I've maintained that same position consistently across administrations. Barr attempted to interrupt, but Crockett held up her hand. "If I may finish my point, Mr. Barr, your 2019 letter asserted privilege over materials that had already been disclosed to private parties and discussed publicly. Information that courts have consistently held cannot remain privileged once disclosed. That's not a partisan observation but a factual assessment based on established legal precedent." This methodical, evidence-based approach transformed what Barr had intended as a political jab into a substantive discussion of legal doctrine, shifting the ground from partisan accusations to constitutional principles. "The fundamental question," Crockett continued, "isn't whether Republicans or Democrats invoke privilege more frequently. It's whether those invocations adhere to established legal boundaries. Is the privilege being asserted narrowly to protect specific presidential communications? Does it yield appropriately to demonstrated needs in criminal investigations? Is it limited to information not already disclosed? These are legal standards, not partisan ones." Recognizing the conversation had moved from political point scoring to legal analysis, Barr attempted to reassert the constitutional basis for his broad view of executive privilege. The Constitution vests executive power in the president. Effective execution of that power requires candid advice, which is chilled when advisors fear congressional exposure. "A legitimate consideration," Crockett acknowledged, "but one that must be balanced against Congress's constitutional oversight authority and the public's interest in governmental accountability. The courts have consistently required this balancing rather than accepting absolute privilege claims." She displayed another document on the screen. "This is a memo you wrote in 1989, during your first tenure as Attorney General. In it, you acknowledged that executive privilege should not be invoked to prevent Congress from investigating wrongdoing, maladministration, or inefficiency in the executive branch." The audience stirred as they recognized Barr's own words being used to challenge his more recent actions. "Your earlier position actually aligns with mine. That privilege serves legitimate functions but cannot be used to shield potential misconduct. The question isn't whether you're a Republican and I'm a Democrat, but whether your more recent applications of privilege adhered to the principles you yourself once articulated." This approach, using Barr's own previous statements rather than partisan talking points, exemplified Crockett's methodical style. Rather than attacking Barr personally, she had identified a tension between his earlier articulation of executive privilege principles and his later application of those principles. Barr, visibly unsettled by having his own words used against him, attempted to distinguish the contexts. Different circumstances require different applications of the same principles. The Obama administration asserted executive privilege just as broadly when it suited their purposes. "That's a testable claim," Crockett responded, displaying another chart. "This data shows executive privilege assertions across administrations, categorized by type and scope. The pattern reveals significant differences, not in the frequency of assertions, but in their breadth and context." The chart demonstrated that while all recent administrations had invoked executive privilege, the Trump administration's claims had been distinctive in their scope, covering entire categories of information rather than specific communications, and extending to individuals in matters far removed from direct presidential advisement. "My position," Crockett emphasized, "has remained consistent regardless of which administration is being overseen. Executive privilege serves important functions when properly limited to actual presidential communications and deliberative processes. It becomes constitutionally problematic when extended to shield potential misconduct or to categories of information courts have held cannot be privileged. This evidence-based approach had transformed the exchange from a typical political back and forth into something more substantive, a serious constitutional discussion about the proper boundaries of executive privilege in a democratic system. The moderator, recognizing the significance of the exchange, allowed it to continue beyond the planned format. Mr. Barr, would you like to respond to the Congresswoman's point about consistency in executive privilege doctrine? Barr, now adopting a more measured tone, acknowledged the complexity of the issue. Executive privilege determinations involve balancing competing constitutional values. Reasonable people can disagree about where that balance should be struck in specific cases. Absolutely, Crockett agreed. Constitutional interpretation requires judgment, and different legal minds can reach different conclusions. My concern isn't that you struck the balance differently than I might have, but that the balance struck during your tenure appeared inconsistent with principles articulated by the courts and by your own previous statements. This acknowledgment of legitimate interpretive differences, coupled with specific evidence of inconsistency, resonated with the audience of legal professionals and students. Rather than simply scoring political points, Crockett had elevated the discussion to serious constitutional analysis. The broader point, she concluded, is that executive privilege isn't a partisan tool, but a constitutional doctrine with established parameters. My criticism of certain privilege assertions isn't based on which party made them, but on whether they adhered to those parameters. That's a position I've maintained consistently throughout my career, regardless of which party controlled the White House. As the moderator moved to the next topic, the audience recognized they had witnessed something rare in contemporary political discourse, a substantive exchange about constitutional principles that transcended partisan talking points to engage with the actual legal standards governing separation of powers. Barr, who had begun the exchange believing he had identified a partisan inconsistency in Crockett's position, now found himself on the defensive, confronted with evidence of his own evolution on executive privilege doctrine. What he had intended as a political gotcha moment had been transformed by Crockett's preparation and precision into a serious constitutional discussion that left him struggling to explain his own shifting standards. The impact of the exchange between Crockett and Barr extended far beyond the Georgetown auditorium. As video clips spread across legal blogs and social media, what resonated wasn't just Crockett's quick refutation of Barr's accusation, but the substantive constitutional analysis she had presented. What made Crockett's response so effective wasn't merely that she disproved Barr's specific claim, noted constitutional scholar David Strauss in a widely shared analysis. It was that she shifted the entire conversation from partisan accusations to constitutional principles. That's remarkably rare in our current political discourse. Legal commentators across the political spectrum acknowledge the effectiveness of Crockett's approach. Conservative legal analyst Jonathan Adler observed, "Whatever one thinks of the Congresswoman's politics, her focus on consistent application of legal principles rather than partisan advantage represents an approach to oversight we should all encourage." Law schools quickly incorporated video of the exchange into courses on constitutional law and separation of powers, with professors using it to illustrate how substantive legal analysis could clarify debates often obscured by political posturing. What makes this exchange so valuable pedagogically, explained Yale law professor Akhil Reed Amar, is that it demonstrates how constitutional principles can and should transcend partisan affiliations. Crockett didn't just win a debate point. She modeled a principled approach to constitutional oversight that students should emulate regardless of their political leanings. For Barr personally, the aftermath brought both challenge and opportunity for reflection. Initially defensive about the exchange, he eventually acknowledged in a Fox News interview that Crockett had raised legitimate questions about consistency in executive privilege doctrine. The Congresswoman made some fair points about the importance of consistent constitutional principles, he conceded. While I still believe my decisions as Attorney General were justified, I respect her focus on legal standards rather than purely partisan considerations. This acknowledgment, that constitutional principles should transcend partisan affiliations, represented an important shift in the public conversation about executive privilege and congressional oversight. Rather than treating these as simply political battlegrounds, more commentators began examining them as genuine constitutional questions with principles that should apply regardless of which party controls which branch of government. Georgetown Law School, recognizing the educational value of the exchange, established an annual debate series titled Principles Beyond Politics: Constitutional Interpretation in Partisan Times. The inaugural event featured experts from across the ideological spectrum discussing how constitutional principles could be applied consistently despite partisan pressures. For Crockett, personally, the exchange enhanced her standing as a serious constitutional thinker rather than merely a partisan figure. Legal organizations from across the political spectrum invited her to speak on executive privilege, congressional oversight, and the separation of powers, recognizing that her approach transcended typical political positioning. What Representative Crockett demonstrated wasn't just quick thinking in a debate, observed former Republican Representative Liz Cheney in a Washington Post opinion piece. She showed how constitutional oversight should function, focused on consistent principles rather than partisan advantage. That approach strengthens our institutions regardless of which party employs it. This bipartisan recognition reflected Crockett's success in framing her position in terms of constitutional principles rather than partisan preferences. By focusing on the legal standards governing executive privilege rather than the party invoking it, she had created space for a conversation that transcended typical political divisions. 3 months after the Georgetown debate, Crockett was invited to testify before the Senate Judiciary Committee on proposed reforms to clarify the scope and limits of executive privilege. In her testimony, she emphasized the importance of consistent standards that would apply regardless of which party controlled the White House or Congress. Executive privilege serves legitimate functions in our constitutional system, she testified, but its boundaries must be clearly established and consistently applied regardless of partisan affiliations. The privilege exists to protect the presidency as an institution, not to shield any particular president from accountability. This approach, focusing on institutional integrity rather than partisan advantage, garnered support from senators of both parties. The resulting bipartisan bill, the Executive Privilege Reform Act, established clearer standards for when privilege could be asserted and when it must yield to congressional or criminal investigations. While not eliminating disagreements about specific applications of executive privilege, the legislation created a more structured framework for resolving such disputes, reducing the likelihood that privilege would be asserted or challenged based primarily on partisan considerations rather than constitutional principles. Legal commentators recognize that this legislative reform, while not solving all problems related to executive privilege, represented an important step toward more principled application of the doctrine. The fact that it had emerged from bipartisan cooperation, initiated in part by Crockett's principled approach during the Barr debate, suggested the possibility of constitutional oversight that transcended partisan divisions. 6 months after the Georgetown exchange, Harvard Law Review published a symposium on executive privilege that included contributions from legal scholars across the ideological spectrum. The introduction specifically cited the Crockett-Barr debate as having elevated public discourse about executive privilege from partisan talking points to substantive constitutional analysis. This elevation of public discourse, from political posturing to constitutional principle, represented perhaps the most significant impact of Crockett's methodical dismantling of Barr's accusation. By focusing on legal standards rather than partisan affiliations, she had demonstrated how constitutional oversight could function at its best, clarifying important boundaries in our democratic system regardless of which party held power. 1 year after the Georgetown debate, its impact continued to reshape both public understanding of executive privilege and how constitutional principles were discussed in increasingly partisan times. The most immediate effect was on legal education. Law schools across the country had incorporated video of the exchange into courses on constitutional law, legislative oversight, and executive power. Professors used it to illustrate how substantive legal analysis could clarify debates often obscured by political posturing. The Crockett-Barr exchange has become our standard introduction to executive privilege doctrine, explained University of Chicago law professor Aziz Huq. It demonstrates both the constitutional stakes and how easily principled positions can be mischaracterized as partisan ones when we fail to focus on specific legal standards. This educational impact extended beyond law schools to civic education more broadly. High school and undergraduate government courses increasingly use the debate to illustrate how constitutional principles could and should be applied consistently, regardless of partisan affiliations. What makes this exchange so valuable for teaching citizenship, noted Princeton politics professor Keith Whittington, is that it demonstrates how constitutional principles can transcend partisan divisions. Students learn that effective democratic participation requires focusing on consistent principles rather than merely supporting whatever position benefits their preferred party at the moment. For practicing attorneys and judges, the exchange catalyzed more rigorous analysis of executive privilege claims. Court decisions in the years following the debate increasingly cited the specific legal standards Crockett had emphasized, requiring privilege claims to be narrowly tailored, recognizing that privilege cannot shield evidence relevant to criminal investigations, and acknowledging that disclosed information cannot remain privileged. Recent judicial decisions on executive privilege show greater attention to established doctrinal boundaries, observed Supreme Court reporter Amy Howe. Judges are more explicitly evaluating whether privilege assertions are consistent with established precedent, rather than simply deferring to executive branch determinations. The Executive Privilege Reform Act, passed with bipartisan support following Crockett's committee testimony, had established clearer procedural and substantive standards for executive privilege disputes. While not eliminating disagreements about specific applications, the legislation created a more structured framework that reduced opportunities for purely partisan invocations or challenges to privilege claims. The new legislation doesn't solve all problems related to executive privilege, noted Jack Goldsmith, former Assistant Attorney General in the Bush administration. But it provides clearer guideposts that make it harder for either branch to take extreme positions based primarily on partisan considerations. Perhaps most significantly, the Crockett-Barr exchange had sparked what political scientists termed the principle-based oversight movement, a growing emphasis in congressional oversight on consistent constitutional principles rather than partisan advantage. Members of Congress increasingly framed their oversight activities in terms of institutional prerogatives and constitutional standards rather than political talking points. We're seeing a subtle but important shift in how some members approach oversight, observed congressional scholar Sarah Binder. Rather than simply attacking the opposing party's administration or defending their own, more members are articulating consistent standards they apply, regardless of which party controls the White House. This shift was particularly evident during a House Judiciary Committee hearing 1 year after the Georgetown debate, when a Democratic representative pressed a Biden administration official on executive privilege claims, using almost identical language to what Republican members had used during the Trump administration. When asked about this parallel, the representative explicitly referenced the Crockett standard of consistent application of constitutional principles regardless of party. For Crockett personally, the aftermath brought enhanced stature as a constitutional thinker rather than merely a partisan figure. Her approach to oversight, focused on legal standards rather than political advantage, had earned respect from legal scholars and practitioners across the ideological spectrum. What Representative Crockett demonstrated wasn't just effective debate technique, observed former Republican Judge J. Michael Luttig. She showed how constitutional oversight should function in a healthy democracy, focused on consistent principles rather than partisan advantage. This bipartisan recognition reflected Crockett's success in framing her position in terms of constitutional principles rather than partisan preferences. By focusing on the legal standards governing executive privilege rather than the party invoking it, she had created space for a conversation that transcended typical political divisions. The Georgetown Law Center, recognizing the educational value of the exchange, had established an annual debate series titled Principles Beyond Politics: Constitutional Interpretation in Partisan Times. Now in its second year, the series brought together legal thinkers from across the ideological spectrum to discuss how constitutional principles could be applied consistently despite partisan pressures. For William Barr, the aftermath had brought both challenge and opportunity. Initially defensive about the exchange, he had gradually acknowledged the importance of consistent application of constitutional principles. In his most recent book, Constitutional Governance, Barr included a chapter on executive privilege that specifically addressed the need for consistent standards regardless of which party controlled which branch of government. While reasonable people can disagree about where to draw certain constitutional lines, Barr wrote, we should all agree that those lines should be drawn based on principle rather than partisan advantage. My exchange with Representative Crockett helped clarify my thinking on this important distinction. This acknowledgement that constitutional principles should transcend partisan affiliations represented perhaps the most significant legacy of the Georgetown debate. What had begun as an attempted political attack had evolved into a genuine conversation about how democratic institutions should function in increasingly partisan times. For the broader public, the exchange offered something valuable, a demonstration that constitutional discourse need not be reduced to partisan talking points. By focusing on specific legal standards rather than political affiliations, Crockett had shown how oversight could strengthen democratic institutions rather than simply scoring partisan points. As Yale law dean Heather Gerken observed in a widely cited article, the most remarkable aspect of the Crockett-Barr exchange is that it ultimately benefited our constitutional system regardless of one's political leanings. By elevating the discussion from partisan accusations to substantive analysis of legal principles, Crockett demonstrated how constitutional discourse should work in a healthy democracy. This demonstration, that principled constitutional analysis could transcend partisan divisions, may be the most lasting consequence of the moment when a former Attorney General thought he had caught a Congresswoman in partisan hypocrisy, only to have her methodically demonstrate that constitutional principles, properly understood, should remain consistent regardless of which party invokes them. If you found this analysis of constitutional principles and governmental accountability informative, please like this video and subscribe to our channel. We bring you in-depth coverage of pivotal moments that reveal how America's democratic institutions function beneath partisan narratives. Thanks for watching.